Hello friends, welcome back to Kayda Vato. Today we are going to explore chapter 36 of the Bhartiya Nagrik Suraksha Sanhita 2023. This chapter titled Disposal of Property. This chapter includes section 497 to 505. This chapter explains us how the court and police deals with the connected crimes property, safeguard it, resolving claims, and also selling perishable things. So let's start the breakdown of this chapter, starting with section 497, order for custody and disposal of property pending trial in certain cases. When the property is produced in the course of an investigation, inquiry or trial, the court or the magistrate may order how the property should be kept while the case proceeds. If the property is perishable or likely to decay, or if it is otherwise expedient, the court, after recording whatever evidence it considered necessary, may order to be sold or disposed of, pending conclusion of proceedings, while preserving an accurate inventory and accounting. So this section deals with the custody and disposal of property pending during the trial, and also which seized by the police during the course of investigation. Section 498, order for disposal of property at conclusion of the trial. At the end of the trial or inquiry, the court may decide the final fate of the property, return it to its lawful owner, order its forfeiture, order restoration to someone entitled, or direct other disposable in accordance with the law and fairness. The court will generally act on the evidence and claims before it to ensure rightful ownership or lawful convictions. Section 499, payment to innocent purchaser of money found on accused. In money or valuables seized from an accused have been purchased innocently by the third party, for example, someone who bought it without notice of wrongdoing, the statute provides for the protecting such innocent purchaser. The court may order payment to them out of the sum seized, subject to proper proof and adjustments. This prevents unfair loss to an innocent buyer while preserving victims' rights. Section 500, appeal against orders under section 498 or section 499. A person aggrieved by an order made under section 498, disposable at conclusion, or section 499, payment to innocent purchaser, may appeal the order to a higher forum as provided by the statute. This ensures review and checks against errors in disposition decisions. Section 501, destruction of libelous and other matter. When materials is found to be obscene, libelous, or otherwise unlawful to keep or circulate, the court may order its destruction, subject to safeguard, recording reason, allowing claims, etc. The aim to prevent further harm while following a fair procedure. Section 502, power to restore possession of immovable property. If immovable property, land, building was seized or its possession disturbed during the proceedings, the court has power to restore the possession to the person lawful entitled once the matter is decided, or to make interim orders to protect rights pending final disposal. This protects title and possession in any orderly way. Section 503, procedure by police upon seizure of the property. When police seize the property, they must follow a defined procedure. prepare a detailed inventory, give notice to interested parties, take custody steps and report to the court as required. Proper record keeping and notice help prevent disputes later about what was taken and why. So this section deals with the procedure when the police sees some property during the investigation. Section 505, procedure where no claimant appears within 6 months. If after seizure no claimant or person appearing to have title comes forward within the statutory period, commonly 6 months, the court or authority may proceed to dispose of the property, often by sale, and deal with the proceeds according to law after following required notice and safeguards. Section 505 to sell perishable property. For perishable or quickly destroying items, the court or officer in charge may sell the property promptly and keep the proceeds safe, often in court account, until claims are resolved. This pragmatic lieu prevents waste while preserving the rights of the victim and claimants. So friends, this chapter deals with the disposal of property. This chapter explains practical rules balancing preservation of evidence, protection of ownership and avoidance of waste. So friends, if you found this breakdown is useful to you, then like, share and subscribe this channel. We will meet soon with next chapter. Till then, bye. Take care. Jai Hind. Stay connected with Kayda ni Vato for more exploration.